The lawsuit was filed on a Monday morning in February, and Clara Woods didn't find out until her granddaughter called from Birmingham with the court filing number and a voice that was trying not to sound frightened. Clara had been on that land her entire life. 82 years on the same 40 acres outside Auburn, the same red clay soil her grandfather had broken with a mule-drawn plow in 1911. A development company called Meridian Land Partners had filed a partition action in Lee County Circuit Court, claiming the right to force a sale because Clara was only one of dozens of heirs and couldn't block them alone. What nobody knew was that the cellar of the old farmhouse held a tin box her grandfather had locked in 1962 and told no one to open until the land was threatened. Clara had waited 82 years. The land was threatened now. In 2023 in Lee County, Alabama, an 82-year-old woman whose family had owned 40 acres since 1911 faced a court-ordered forced sale of that land, worth an estimated $20 million, through a partition lawsuit filed by a development company that had spent years acquiring fractional heir interests to gain legal standing. Clara Woods had been born in the farmhouse on Sycamore Road in 1941. Her grandfather, Elias Woods, had purchased the 40 acres in 1911 from a white landowner named Carver for $340, money he had saved over 11 years of labor. He had the deed recorded at the Lee County Courthouse on a Thursday afternoon in March, an act of deliberate legal formality in rural Alabama in 1911. He cleared the eastern field that first summer. He built the farmhouse in 1914. He died in 1963, leaving the land to his children in a handwritten will the county probate court accepted without dispute. The land had passed through 3 generations in the way that rural black family land in Alabama often passes, not through clean probate and updated deeds, but through informal inheritance, family consensus, and unwritten understanding. Clara's father had farmed the eastern field through the 1960s. Her uncle had kept cattle on the western pasture through the 1970s. Clara herself had stayed when her siblings moved to Birmingham and Detroit and Atlanta, stayed through her marriage to Robert, who died in 1998, stayed through her children's departures, stayed through the decades when Auburn grew from a small college town into a city that pressed outward until the Sycamore Road parcel sat like an island surrounded by subdivision development. The land's value had climbed with the city. A commercial appraisal in 2019 estimated the parcel at $14 million. By 2023, the estimate had risen to $20 million. Meridian Land Partners had been circling the property for 11 years. They had sent representatives to the farmhouse twice, with offers that Clara had declined without extended discussion. What Meridian did instead was patient and systematic. Over 8 years, they identified every heir with a fractional ownership interest in the parcel. Legal title was shared among 41 individuals, most of them Clara's cousins and their children, many of whom had never set foot on the property. They approached these heirs individually, offering cash payments for their fractional interests. By 2022, Meridian had assembled fractional interests totaling approximately 31%. They did not need a majority. Under Alabama partition law, any co-owner can petition a court to force a sale of jointly held property if the co-owners cannot agree. 31% was more than enough to file. The distant cousin who provided the final piece was Derek, the grandson of Clara's father's younger brother, who lived in Atlanta and had visited the property exactly once, in 2009. Derek had sold his fractional interest to Meridian in December 2022 for $18,000. He had not told Clara. Clara found out when her granddaughter Amara called with the court filing number, because Amara worked for a law firm in Birmingham and knew how to read a partition complaint. Clara listened to Amara explain the filing without interrupting. When Amara finished, Clara said, "Go look up the name Joseph Terrell in Birmingham. He was your great-grandfather's attorney's son. He does land law. Call him today." Then, she put on her coat and went to the cellar. The cellar entrance was a wooden hatch set into the floor of the back room. Clara worked her fingers under the edge and lifted. The cellar stairs were 7 steps, steep and narrow, lit by a single bulb on a pull string. The cellar itself was low-ceilinged and divided by the original fieldstone foundation piers into 3 sections. Clara had not been down here in 4 years. The tin box sat on the lowest shelf of the storage rack along the north wall, behind 2-gallon jars of preserved peaches. It was approximately 12 inches long and 8 inches wide and 4 inches deep, painted green, the paint now mostly gone. The padlock through the hasp was small and old, with surface rust, but the shackle moved freely when Clara applied the key. The key had been on her keyring for 60 years. Elias had pressed it into her hand in the autumn of 1962, when she was 21 and newly married. He had taken her aside after Sunday dinner and said, "You're the one who's staying. This key is for you. Don't open that box unless someone tries to take the land. If they try, open it first, before you do anything else." She had asked him what was in it. He had said, "Proof." She had carried the key for 61 years without using it. She set the box on the shelf and opened the lid. Inside, wrapped in oilcloth that had hardened with age, were 6 documents. The first was the original receipt for the 1911 land purchase, signed by the cellar carver and witnessed by 2 named individuals. The second was the original recorded deed from Lee County, with Elias Woods listed as sole owner. The third was a declaration of intent, dated 1938, signed by Elias and all 4 of his adult children, stating that the land was family homestead property, intended to remain in the Woods family in perpetuity. The fourth document was a letter from a Birmingham attorney named Marcus Webb, dated 1955, advising Elias on the legal options for protecting the land from forced partition. The letter described a legal instrument called a heirs property declaration. Clara unfolded the attachment. It was a recorded covenant, filed with the Lee County Probate Court on April 4, 1955, establishing that the Sycamore Road parcel was subject to a right of first refusal by the direct lineal descendants of Elias Woods, before any interest could be sold to a non-family party. The covenant had been recorded and was part of the chain of title. Nobody had looked at it in 68 years. The fifth document was a survey map of the parcel from 1948, hand-drawn. The sixth was a short note written to Clara directly in her grandfather's handwriting. It said, "If you are reading this, the land is worth more than they told you. Find a lawyer who knows quiet title. The covenant is recorded. Use it." Clara stood in the cellar for several minutes after reading the note. Then she climbed the stairs, pulled the hatch closed, put the tin box on the kitchen table, and called Amara back. She said, "I found what we need. Tell Joseph Terrell to call me tonight." Joseph Terrell III ran a property and civil rights law practice in Birmingham. He was 54 and had spent 20 years working on heirs property cases across Alabama, Georgia, and Mississippi. When Clara described the contents of the tin box, and when Amara read him the language from the 1955 covenant, Terrell was quiet for a moment. Then he said, "Your grandfather was a careful man." Clara said, "He was." The legal mechanism Terrell identified as the primary defense was the Uniform Partition of Heirs Property Act, which Alabama had enacted in 2020. The act was specifically designed to address the situation Clara faced. It gave courts discretion to deny a forced sale when the property was heirs' property and when the partition would be inequitable, particularly when one co-owner had lived on and maintained the land. Terrell filed a response to the partition complaint in March 2023, invoking the act and requesting that the court appoint an independent appraiser, evaluate the buyout option, and consider the full equitable context. The 1955 covenant was the second front. Terrell filed a separate motion arguing that the right of first refusal covenant, recorded in the Lee County Probate Court chain of title, applied to every fractional interest Meridian had purchased. If the covenant was enforceable, Meridian's purchases were voidable. Each heir who had sold a fractional interest to Meridian without first offering it to the Woods family had violated the recorded restriction. Meridian's attorney argued that the covenant was unenforceable as an unreasonable restraint on alienation, and that its age had rendered it abandoned. Terrell replied that a recorded covenant does not expire through non-enforcement, that the restraint was reasonable and specific, and that Meridian's own title search should have surfaced it. The confrontation came at a hearing in Lee County Circuit Court in May 2023. Meridian's attorney argued that the partition was straightforward. Their client held a valid fractional interest. The co-owners could not agree, and the court was required to order sale. Terrell stood and said the court was not required to order anything under the Uniform Partition Act until it had evaluated every equitable factor. He said the court had before it a recorded covenant that predated every one of Meridian's purchases, a co-owner who had lived on and maintained the land for 82 years, and a development company that had systematically acquired fractional interests, specifically to manufacture legal standing to force a sale. He said the legislature had passed the act in 2020 precisely because this pattern existed and precisely because it was inequitable. Judge Arlene Coates scheduled a full evidentiary hearing for September. Derek, the cousin who had sold his interest to Meridian, contacted Clara's family through an intermediary in July. He said he had not understood the full situation and was willing to cooperate. Terrell noted this in a filing that also included affidavits from 11 other heirs who formally supported Clara's position. 3 heirs, who had sold interest to Meridian, submitted sworn statements that they had not been informed of the recorded covenant at the time of sale. In November 2023, Judge Coates issued her ruling. She found that the Sycamore Road parcel qualified as heirs property under the Act, that Clara's 82 years of occupancy and maintenance constituted a special equitable interest that a forced sale would destroy, and that Meridian had engaged in a pattern of acquisition designed to circumvent the family's collective interest. She denied the partition by sale. She ordered instead that the family be given 18 months to arrange a buyout of Meridian's assembled fractional interests at fair market value for those interests, not at the full $20 million property value, but at the proportional value of a 31% fractional interest in a property whose sale the court had just ruled could not be compelled. Meridian did not appeal. The math had changed. The buyout was completed on March 7, 2025, in the offices of a Birmingham title company. Meridian Land Partners accepted $2.3 million for its assembled fractional interests, the proportional fair market value of a 31% minority stake in a parcel whose partition had been denied. The payment came from a combination of a land trust loan secured by the property and contributions from 11 family members who pooled resources. The deed transferring Meridian's interests back to the Woods family heirs was recorded with the Lee County Probate Court on March 9, 2025. The 1955 covenant remained in the chain of title, now freshly litigated and confirmed enforceable. Clara did not attend the closing. She sent Amara and Terrell and said she would be at the farmhouse. When Amara called from the title company parking lot to say it was done, Clara was in the eastern field looking at the section of fence line that needed replacing before spring. She said thank you. She put the phone in her coat pocket and told her helper which posts needed pulling first. The 40 acres remained exactly as they had been. Red clay soil, the longleaf pine stand along the eastern fence, the farmhouse Elias had built in 1914. Claire had the survey map from the tin box framed and hung it in the hallway beside a photograph of Elias, taken sometime in the 1940s. The original 1911 deed was in an archival sleeve in a fireproof box Amara had brought from Birmingham. The 1955 covenant was in the same box, with Terrell's annotated copy of Judge Coates's ruling. In spring 2025, Clara contacted the Alabama Farmers Federation and the Federation of Southern Cooperatives, which provided legal and financial resources to black landowners facing heirs property challenges across the South. She made a donation and spent an afternoon describing the specific sequence of events. The coordinator asked if she would be willing to speak at their annual conference in Montgomery that fall. Clara thought about it for 2 days and then called back and said yes. The tin box was back on the cellar shelf, behind the peach preserves, with the oilcloth folded inside and the lock fastened. The key was back on Clara's keyring. She did not think of it as a thing that had saved the land. The land had been there before the box and would be there after. Elias had saved it in 1911 when he walked into that courthouse in Auburn and stood there while the clerk stamped the deed. He had saved it again in 1955 when he found Marcus Webb and paid for the covenant to be recorded. He had saved it a third time in 1962 when he called Clara aside on the back porch and pressed a small key into her hand and told her what to do with it. On a Sunday morning in April, with the eastern fields showing the pale green of early grass and the pines throwing long shadows across the fence line, Clara made coffee and sat on the porch in the same chair she had sat in for 40 years. The city was visible now from the south edge of the property. Rooftops, a water tower, the glint of glass from commercial development. It came no closer. The fence line held. The red clay ran to the edge of her land and stopped there, the same as it always had, the same as it was going to.